I'm Jim Check. You're watching Now Media. With me, Geoff Moyse, King's Counsel. And we're here to talk about an issue that is kind of getting a lot of action on social media for sure. It's that BC court ruling on the land there in Richmond. And I guess the question is, what does it all mean for the average British Columbian? And thank you for doing this, Geoff. Maybe tell us a little bit about your background first, just so people get an understanding of what your experience is.
Sure. Thanks for having me on. I spent 33 years in legal practice on these issues. I worked for the government for 31 years. That's 6 successive provincial governments. Over 31 years, I was senior counsel in the BC government for that time. And my practice was Aboriginal and treaty law. So this is an area I have some familiarity with over time. And particularly as a government lawyer, I've seen things from that perspective.
Yeah, so we would call you an expert in this area for sure. 31 years with the government and 33 years practicing in Aboriginal law. I think that would qualify you.
I hope so.
What does that ruling mean, though? Because I mean, we've seen some stuff from John Rustad, the Conservative Party. I had that interview with Renee Merrifield, and then there's an article we put up on Kelowna Now this morning, and it had a former Richmond City Councillor there, Harold Steeves, is talking about it as well. That's on Kelowna Now if you want to go and read it. And he was said he is surprising by the ruling last week. What does that ruling mean to the average British Columbian? Or maybe give us background first, whatever you want to start.
Yeah. So a little bit of background. I think people need to understand the fundamental differences in this province between policy and law. This ruling, of course, is from the BC Supreme Court. It's a ruling of law. It comes from the constitutionalization of Aboriginal rights in 1982 in the Constitution Act. So at that time, we decided as a country to enshrine Aboriginal rights and treaty rights in the Constitution. Now, the effect of doing that was twofold. First of all, nobody knew what exactly Aboriginal rights meant when we did that. It was kind of an unknown, but we did it anyway. And the other thing is that when you put something in the Constitution, it becomes the supreme law of Canada. And so when judges in
I think he just froze. We'll give it a second, see if it comes back. I don't know, Geoff, if you can still hear me. You may have to call back into the feed. Just cut out. I think he just dropped out. Hopefully he just comes back in right away. We'll just wait patiently. There you go. Just heard him down. There you go. Thank you for coming back in. You were just talking about constitutional law and you froze.
I froze. Okay, so the point I was trying to make is that the Constitution is the supreme law of Canada. So when the Supreme Court of Canada interprets the Constitution in the way they have, suddenly Aboriginal title becomes part of Aboriginal rights. And there's a whole bunch of jurisprudence from the highest court about what that means. So this judge in Richmond is, in the Richmond case, she's applying law that's been set down over probably the last 15 or 20 years by the Supreme Court of Canada. I think that's important for people to know. This is a legal judgment. This is not the EUB government's policy. It's not UNDRIP. It's none of those things. This is actually a legal judgment pursuant to the Constitution of Canada. Now, the issue that's central to this judgment, of course, is it limited to just those fee simple parcels, those private land parcels in the declared title area in Richmond, or does it have broader implications for other land interests in the province, other private landowners across the province? Unfortunately, I think that maybe Justice Young extended her reasons for judgment too far. And instead of limiting her decision to the Richmond lands, where she had particular reasons for saying that those fee simple interests were suspect because of the colonial record, she's basically extended that and said, well, this is a precedent for the entire land title system in BC. And I think that's the problematic part of the judgment. So what does it mean? It means, remember that Aboriginal title does not blanket the entire province. The cases we've had on Aboriginal title have found it's about 5% of claimed territories. So it's huge. But Chilcotin got about 1,800 square kilometers of tidal land in their case in the Caribou. So it's not insignificant. The problem is that a lot of places where Aboriginal title is likely to be proven are places where we have land settlements that have been created by the Crown. So typically valley bottoms, anywhere there's a river. And, there is an intersect between the likelihood of Aboriginal title and where we have settlements with a lot of private land interests in BC. Probably the biggest example would be Vancouver. So is this a judgment that people need to be concerned about? I don't think you need to get your hair on fire yet. This judgment's going to go through the BC Court of Appeal. It's going to go to the Supreme Court of Canada. And the issue that the Supreme Court of Canada is going to have to wrestle with is, what is this relationship between this constitutionally protected thing called Aboriginal title and private land interests granted in large by the provincial government, but in some cases by Canada? That is an unanswered question. Judge Young has waded in with her views on that question, but this has got a long, long road to go before there's any definitive determination.
Yeah, and her judgment there, she said that the Crown and City titles are defective and invalid, and then she put about an 18-month hold on that before they transferred titles. And I guess that's allowed the system to kind of, you would think for sure this would end up at the Supreme Court of Canada, because it obviously has some far-reaching implications and ramifications to private landowners that have been awarded that land by BC land titles, Alberta land titles, Canada.
That's correct. She's basically thrown into question the entire land title system in those circumstances where there may be a strong claim of Aboriginal title that ends up being proved in court. Now, that's pretty significant. The other thing is that her declaration of invalidity for these private land interests in Richmond, that's based entirely on the history of that site and some colonial stuff that went on, where she says that site was promised to be reserved for the Cowichan and then wasn't. So those declarations of invalidity are very much about the Richmond site. Having said that, her reasoning could be applied anywhere Aboriginal title is proven and there are private land interests in that particular land.
Yeah, John Rustad, I watched an interview on the Candace Malcolm show. I mean, he calls into question land all over BC if this ruling is upheld.
Well, as I say, we need to be careful about that, because Aboriginal title, at least the way the courts have determined it in BC to date, and we've had 3 judgments, one in New Chatlet, one in Chilcotin, one now in Richmond. These are pretty small areas in the grand scheme of the British Columbia land base. So I think people need to know that this title interest is very unlikely to blanket the whole province. But that doesn't mean that it can't have really serious ramifications when you basically have a judge who's putting a cloud over everybody's title. And the ramifications are unknown as to how that's going to work. I mean, does the Real Estate Association now have to put some sort of disclosure in their purchase and sale agreements about
how would you get a loan?
Your land could be subject to a claim of Aboriginal title, and if it's proven, you may lose your interest in land. The other thing I wanted to say quickly about the Cowichan circumstance, the unfortunate piece of this is the judge's determination that Aboriginal title and fee simple title can coexist. I think there's a lot of us, a lot of my colleagues who've practiced in this area for a very long time, who think that's basically wrong in law. You can't have 2 parties having the exclusive right to occupy and use a piece of land. What she's done in Cowichan is she said, well, they're coexisting for now. But she's also said that any time Cowichan want to pursue an action for ejectment of those private landowners, they have the legal capacity to do that now. So basically, it's not that they're coexisting, it's that the private land interests are unaffected until the Cowichan say, you're out. And
Yeah, so that brings into question a lot. Yeah, go ahead, sorry.
I have faith that I have faith that the Cowichan aren't going to do that. They didn't ask for a declaration of to that effect for the private lands. They said they weren't going to take back private lands, but they have the capacity now legally to do that.
Yeah, and that would make it really rough for people to sell the property, to like exchange it, and then for the new people to get a mortgage on it and all kinds of things, because obviously the banks look at risk and different things, and then obviously the future landowner looks at risk as well.
Well, yeah, both the banks and future landowners are going to look at the situation and say, well, what you're saying is essentially I could be on this piece of land until the Cowichan tribes tell me otherwise. And that's not a lot of legal certainty for an investment.
Yeah, I mean, I personally have purchased land on First Nations land with property that they enter into I don't know if it's a 110-year lease or something like that, but you're going into that arrangement knowing full well what it is. And I guess those could be some of the arrangements that are made. Because I mean, in all honesty, most land is still owned by the government. It's kind of like a forever lease as well.
That's true. All of these crown titles or these legal titles, these fee simple titles, they all track back to the crown originally. So they all came from land that was granted by the crown at some point in time. Sometimes the federal crown, most often the provincial crown, but they all track back to the crown's interest in land. Now, Aboriginal title has been held by the Supreme Court of Canada to be a burden on that crown interest in land, and so that creates the issue of what's the interplay between crown grants and Aboriginal title. And one judge has now weighed in to say, well, Aboriginal title is now the superior interest in those lands.
So a couple of questions come to mind for me there is like, what are the actions that the current landowner would have? Can they sue the government then for selling them land that they didn't own? And then the basis of taxation from BC land titles and the BC government, do they have a right to tax that land?
Well, right now I think it's clear that everything is status quo. So all of those things are in play. In terms of taxation, nothing's changed because those lands, she's basically said, those interests are there. They're able to continue at least until Cowichan says otherwise. So I think that the whole status of those lands is continuing for now. But there's a cloud now over those titles because they are now at sufferance of the Cowichan tribe's whims about what they're going to do with the land. That's one thing. I think that the other aspect of this is probably that those titles in Richmond, remember that the Attorney General has just said she's going to seek not only leave, she's going to appeal the judgment, but she's also said she's going to seek a stay. Now, the point of that would be to say, I want the declarations in this judgment to be stayed while this goes to appeal. Now, if she's successful in that regard, then the judgment becomes, for the time being, moot. It just sits there. It has no legal effect while a stay is in place. I don't know if she will get a stay from the courts for this judgment. She may not. But if she does, then it will all be on hold pending a determination in the Court of Appeal and ultimately a determination in the Supreme Court of Canada. That could take several years.
But it's not just the Cowichan First Nations. It's several First Nations groups that have laid claim to this land as well. And Cowichan obviously is on the island, and this is not on the island. And does that make it even messier?
It makes it messy from two particular perspectives. in terms of the Cowichan lands themselves, Musqueam, and I know from years of legal practice in this area, Musqueam have very good claims around that area. The Musqueam have an Aboriginal right to fish in the Fraser, which was found for them in 1990 in the Sparrow case. I understand the Musqueam are highly unhappy with this particular judgment and have different views about whether Cowichan actually should have been granted Aboriginal title to these lands in Richmond. I think the Musqueam believe they're their lands historically. So yes, it's created that difficulty between neighboring groups in Richmond. But imagine the whole province is subject to these kinds of overlapping claims. And so if one First Nation proves title over somebody else's property, or if a treaty is done like the Niska agreement, the Gitniao turn around and say, wait a second, you put treaty lands over our lands. And so the overlap issue is huge. It's everywhere in BC. So it's not just a question of the relationship between the public and Aboriginal title. It's the question of the relationship between Indigenous neighbours and Aboriginal title. And this has probably fanned the flames of that problem to some extent.
Yeah, I'm in Kelowna here, and Kelowna, as well as the Okanagan, are both Aboriginal names, and so that lends well to land claims as well, likely. But what does that mean, for the average British Columbian right now? Should they be worried, or what would their actions be if all of a sudden their land was the title was given to Aboriginals, and then could they then sue the BC government, or what would they have to do, I guess?
Well, I think if an Aboriginal title declaration was made over my private property, the first thing I would do is sue the provincial government. One of the questions I think in this case in Richmond is, will the private landowners get themselves together and not only determine whether it's timely to begin an action against the provincial government for damages. It may or may not be a right time to do that, given that their interests are kind of still there, but on the whims of the Cowichan. That may be enough to bring a damages claim against the province. But the other question that is pretty important in this is that those homeowners, in particular, the private landowners in Richmond, I believe, probably should group together pretty quickly, get themselves very learned legal counsel, somebody like Tom Isaac or Robin Younger, to bring an intervenor status application when this goes to the Court of Appeal. They should be there as residents. They are affected by this judgment. They will have standing, I'm sure. They need to band together and get themselves into this lawsuit as interveners, because someone needs to plead that in the Court of Appeal needs to plead this whole question of extinguishment of Aboriginal title by the issuance of fee simple crown grants. It was not argued, and I'm astonished by this, I have to say, it was not argued by the province that these grants extinguished Aboriginal title. It was not argued by Canada. And so now it's an uphill battle for anybody to get in front of the Court of Appeal and say, these interests, these Aboriginal title interests in these private lands, they've been extinguished by the nature of the Crown Grant. So somebody needs to do that, and I'm hoping that the homeowners or those affected by this judgment may get together and seek intervenor status with good counsel.
Yeah, obviously all of that, what you said, means this is likely going to end up in the Supreme Court of Canada, because I don't think anybody's going to be happy no matter what happens in the judgments from the BC courts, right?
That's true. This is an issue that the Supreme Court of Canada has managed to, if I can use the word duck. They haven't ducked it intentionally. It's just never actually been put before them in a way that they can't not comment on it. So this is probably the biggest issue in Canada the relationship between prior Aboriginal title and private land interests in Canada. This is probably the biggest issue they're going to ever face as a court when they're dealing with Section 35 of the Constitution Act. So it has to go to them.
Yeah, I think a lot of people, aren't really thinking about it, but we're likely, like these people, the private landowners right now have some type of impairment on that land because their ability to sell it right now is probably, at a lower value because you don't know what the outcome's going to be. And, and again, mortgages on this property right now will probably even be tougher to get.
The term that the lawyers use is a cloud. There's a cloud on those titles now. And I would expect the very first implication of that cloud is going to be a devaluation of those properties. Whether they will be able to be sold is another question, but I think an immediate devaluation is probable. That's one of the impacts of this judgment.
So this is significant, and this is, do you know of many other cases out there that are close to a judgment like this right now in BC and or across Canada?
I don't actually. There's not a plethora of Aboriginal title cases before the courts in BC. I think there's a reason for that. And I believe the reason for that is that, and I don't mean to be disparaging in my remarks here, but I think there is value to Indigenous communities to hold out for the notion that they have title to their entire territories, rather than going to court and finding that it's only title to 800 acres of land. I think there's a lot of leverage to be gained by maintaining that title is everywhere in your territory. I think, unfortunately, the government's adoption of UNDRIP, the UN Declaration on the Rights of Indigenous Peoples, through their legislation DRIPA, I think, unfortunately, what's happened is that's meant that the definition of title in UNDRIP, which is much broader than the definition of title in the Supreme Court of Canada, is now being used to bolster that argument that, in effect, Indigenous title is everywhere in claimed territories. And I think the government has kind of adopted that. If you look at what they did in Haida Gwaii, they basically said, well, the Haida, we're going to declare that the Haida have Aboriginal title to the entire Haida Gwaii archipelago. We're not going to look at the legal tests from the Supreme Court of Canada for proving title. We're just going to declare that it's over the entire archipelago, including the private lands on Haida Gwaii. And then we're going to come up with a cleverly invented scheme to try and ensure that the private landowners are not impacted by that declaration. Myself and other leading counsel in this area do not believe that arrangement that they put in place for the private landowners is actually constitutionally sound. But that's a pretty good example of when you put UNDRIP ahead of the case law in Canada from the courts, and you end up with an entire territory blanketed in Aboriginal title and private land interests carved out under some form of arrangement for continuing provincial jurisdiction.
So the BCNDP have now appealed this decision. What do you think the difference is? Like you said, it's not really had anything to do with the NDP at this point. What is the difference between how they appeal that versus like a Conservative Party appealing it? Or what do you think the differences would be there?
There's one major difference that I would focus on. In 2021, or 2022, I guess it was, April 2022, the BC government the Attorney General issued a directive to his litigators in legal services branch that they would no longer do certain things in litigation. They would no longer plead certain defenses on behalf of the Crown. One of those was they will not plead extinguishment of Aboriginal rights or title in any circumstances. So the BC government finds itself in an awkward position because it's done this Richmond case tying its hands behind its back in terms of litigation. It's basically gone in and said, well, there's an argument to be made that that this title was extinguished by these fee simple interests. It's an argument that has to go to the Supreme Court of Canada. But guess what? We're not going to make it. We're going to leave it aside in this litigation. That was, I think, a political decision, and I think a huge mistake. And I will say Canada did exactly the same thing.
So that's why you're saying the private land interests need to get together and and do that themselves.
Yeah, I think there needs to be one of two things happen. Either interveners, like the private landowners who have standing, I think, to intervene in this appeal, need to get together and bring that argument fully in front of the Court of Appeal, which the province and Canada declined to do. And that's going to be an uphill battle because the court's going to look at those interveners and say, well, why didn't the province say this? Why didn't Canada say this? And that's very awkward. The other possibility is that the court could be asked to appoint an amicus curiae. That's basically a friend of the court. So that would be someone to put this argument in front of the court in a coherent and comprehensive basis that the province and Canada failed to do. That is a possibility as well. And so I think that the bottom line is that I'm not terribly comfortable relying on the BC government to appeal this case when they've basically given away one of the strongest arguments that they had at the trial.
And you say you've worked for several governments. I mean, it's switched over time, over 31 years. Obviously you've been through the gambit of the Liberals and the NDP and.
I started my career working on the Nisga'a Final Agreement, which still is one of the things that I'm most proud of that we accomplished. I'm interested in treaties in BC, of course, because I think they are actually the gold standard for reconciliation. Unfortunately, I think the government's interest in UNDRIP and its determination to apply UNDRIP rather than Canadian law wherever it gets the chance, I think that's basically undermined the treaty process to a large degree, and I think that's unfortunate. I still believe that reconciliation has to be done under the terms of Section 35, and that means either do a treaty or litigate the issue. This notion of doing agreements based on vague principles in the United Nations Declaration, I don't think that's going to do anything except create division throughout the province.
Did you freeze again, or are you still there? I think you're. Hey, Geoff, we're just waiting for your connection to get a little better.
Still here.
Awesome.
Okay, just.
Well, I think we lost you now. We'll just give it a second and see if he comes back. Lots to unpack there. There's a good. Here he is, back.
There we go.
You're back. Thank you for coming back.
So, sorry.
No problem. Do you think this ruling will now stoke or get a bunch more claims put forward across Canada?
Maybe. I don't really think so. This judgment is largely about the circumstances on this parcel of land in Richmond. It doesn't change the law of Aboriginal title in Canada. So anybody who has a valid Aboriginal title case that they can bring to court, they're able to do that before, they're able to do it now. I'm not sure that changes anything, except if a First Nation wants to argue somehow that private lands in their claimed title area are now in issue. I don't think anything really changes as a result of this judgment. Now, most Indigenous communities who've been litigating these issues in Canada have been very careful not to implicate private land. And so this is the first case where private lands were brought into issue by a First Nation in a title case. I don't know if there's a lot of appetite out there in other Indigenous communities to bring title cases to displace a private land interests. I think a lot of communities would say, well, whatever that is, it's probably not going to lead to reconciliation. So I don't know that it will fuel a lot, but its bigger implication, of course, is for the land title system in BC.
Yeah, I think one of the things that has gotten people, like the Conservatives, and this paragraph in here where she writes that she's going to give, she suspended the declaration of land titles for 18 months. So the federal government, the city of Richmond, will have the opportunity to make necessary arrangements. And then she continued to say that a period to allow for orderly transition of the lands in keeping with the principle of reconciliation. I think that's obviously caused, some of the stir, but obviously there's like 18 months, and then there's going to be appeals to this case as well.
Yeah, the deadline for filing the appeal in the Court of Appeal, I know the province has already said they're going to do that. The deadline is basically 30 days after the judgment was issued. So I'm assuming, without knowing, that Canada will appeal. I would assume that Musqueam will appeal. And I'm hoping that there will be someone else showing up in front of the Court of Appeal to argue this whole issue of the relationship between fee simple title and Aboriginal title much more fully than the City of Richmond was able to do in the trial process.
How long do you think before we see a judgment from the Supreme Court of Canada? Are we talking 5 years, a decade, or?
I would expect that it will take at least 4 years. It's really hard to predict, but it's not going to happen overnight.
Yeah, these things take a long time for sure, right? For people to get their information together. And obviously there's a number of parties involved in this, private landowners, Cowichan, and then Musqueam, and then I think there was another party as well, all these cities, Richmond, the province of BC.
First Nation, right. The BC Port Authority, the City of Richmond, were all parties to this litigation. They all have an ability, presumably as parties, to file an appeal.
So what is the land in question? Maybe just give the viewers an idea of what land we're talking about, because it is some commercial properties, some private lands, and some BC-owned lands as well.
Well, I understand that it's kind of a mix of things. It's about somewhere around 800 acres, I believe. I understand there's about 137 private properties, as in private owner properties, on the land. I know there are some big commercial interests. There's, I think, a Wayfair depot. A
Walmart, I think, as well, yeah.
Walmart. There's some box stores. And I think some of those private residences are probably quite close to the river in the form of condos. I'm not actually sure, but I've seen some pictures of those. So there's a real mix of interests. There's a golf course. And there's some crown lands, of course. So it's a mixture of a whole bunch of uses. You can picture it. It's an industrial area of the Fraser River bank, industrial, but also residential. So it's a total mix of different kinds of interests.
Yeah, there's a good story on KelownaNow.com right now where you can go and read, and it kind of outlines, some of the current land users of that property.
Yes.
Yeah. Anything else you want to add?
Not entirely, but I think it's time for people to start to work to get an understanding of what's going on in this province with Indigenous reconciliation. I think one of the unfortunate things is you've got a government that has been storming ahead based on its own ideology and the United Nations Declaration, which I don't think they've been bringing the public along with them on that. I think that, in fact, they've been entirely secretive about it. And I just see that that's a recipe ultimately for divisiveness and not for reconciliation. So I would urge people to get up to speed on these issues and start to understand all of the policy stuff that's going on, not just the legal judgments coming out of the courts, but everything else the government is purporting to do in the name of reconciliation, which I don't know that the general BC public have ever been asked about.
Yeah, and I think you highlighted one really key point there, the extinguishment that the government of British Columbia and the government of Canada are not using that as a defense.
That is entirely an ideological choice by the current government. I'm assuming that if the Conservatives were in power, they would not issue those kind of instructions to their litigators.
Well, I do thank you for your time, and it'd be great to have you back again, because I'm sure that there's a lot of, I guess, I don't know, they use the words misinformation, disinformation, or people's interpretation of what this ruling means. Overall, I think that is the one thing, is their interpretation. I don't like using those words, misinformation, disinformation, but just interpretation of the ruling, I think, is more so, where I think, the different parties are using their own interpretation, right? Yeah. And I guess that's what law is, though, too, right? Interpretation, right? That's why you argue cases.
Well, it is why we have courts of appeal. No question. You can't just have these kinds of issues being resolved by one judge. It needs panels of judges to look at them and to consider them, for sure.
I think this one is very serious, and obviously getting it to the Supreme Court of Canada is where it's going to end up anyway. So the faster they can get it there, the better.
I think that's true.
All right, I do thank you for your time, Geoff, and we'll again maybe we'll reach out again and get more information for you. That's been great for sharing your knowledge.
I would be very happy to do this again, and thank you for having me on.
Thank you, and thank you for watching Now Media.